So the Supreme Court has denied review of a case which involves whether firearms magazines are actually firearms parts protected by the PLCAA and whether or not companies that make and sell these magazines can be sued and be held liable. So let's talk about this. But real quick before you jump into this video, if you think it's time for the Supreme Court to take up more two-way cases, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they are huge Second Amendment supporters. They have dedicated roasts for organizations like FPC and GOA. So if you purchase those dedicated roasts, some of the proceeds go directly to those organizations so that they can file more lawsuits. So again, amazing coffee, huge Second Amendment supporters. You can check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we're going to be breaking down an interesting firearms case, which was just denied review by the Supreme Court. The case is called KCI versus the 8th Judicial District Court of the state of Nevada. In this case, a manufacturer of firearms magazines was sued because one of their magazines was used by a criminal. The family of the victim then sued KCI in an attempt to hold them liable for the negligent manufacture of a product that was then used in a crime. This whole case revolves around the PLCAA and whether or not a manufacturer like KCI as a company can be held liable because of the acts of a third-party criminal. Now, the facts that led to this case are as follows. KCI is a company that manufactures, imports, and distributes magazines to wholesalers for semi-automatic firearms. So essentially, they just make standard capacity magazines. One of KCI's magazines was used in the furtherance of a shooting that occurred on August 4th, 2019. On August 4th, 2019, an individual criminally misused one of the KCI magazines to essentially perpetrate an unlawful shooting, a criminal creating a crime. But then the family of the victims filed a lawsuit against KCI based on their allegation that the company engaged in negligent manufacture of a magazine. KCI subsequently moved to dismiss the lawsuit against them on the basis that its magazine is a component part of a firearm and therefore entitled to the protection and immunity under the Protection of Lawful Commerce in Arms Act. This case was originally before the 8th Judicial District in Clark County, Nevada, and on review, the court held that KCI's magazine was not a component part of a firearm eligible for immunity under the PLCAA. Therefore, the court denied KCI's motion to dismiss the case. KCI, in response, then filed a writ of mandamus up to the Nevada Supreme Court, alleging that the lower court clearly committed an error by denying the motion to dismiss because the firearms magazines, in their eyes, were clearly a component part of a firearm that were afforded protections under the PLCAA. However, the Nevada Supreme Court, on review, also denied KCI's petition, and they denied that writ of mandamus. That has now then led to the KCI and this company filing a writ of certiorari up to the Supreme Court and asking for the Supreme Court to step in. The question presented to the Supreme Court was simply whether a magazine is a component part of a firearm under the Protection of Lawful Commerce in Arms Act. Now, you may be asking yourself, what is the Protection of Lawful Commerce in Arms Act, also known as the PLCAA? The PLCAA is a U.S. law that protects firearms manufacturers and dealers from being held liable when crimes have been committed with their products. This is a law that is supposed to prevent a person from suing a gun manufacturer or dealer when a third party takes a gun and commits a crime with it. Under the PLCAA, any action brought by any person against a manufacturer or seller of a qualified product or a trade association for damages, punitive damages, injunctive or declaratory relief, abatement, restitution, fines, or penalties, or other relief resulting from the criminal or unlawful misuse of a qualified product by the person or a third party is barred. The PLCAA defines a qualified product as a firearm, including any antique firearm or a component part of a firearm or ammunition that has been shipped or transported in interstate or foreign commerce. This means that the PLCAA is intended to provide protection not just to firearms, but also ammunition and then parts as well. However, in this lawsuit, the courts found that this case should not be dismissed under the PLCAA because in their eyes, they did not believe that a firearm magazine is a component part afforded protections for this type of lawsuit. The two main reasons that the lower court is argued to have found that the rifle magazine is not a component part under the PLCAA is because they said that the rifle could still fire one shot without a magazine, and also because a magazine was not purchased or sold with that specific rifle that was then used. So they're saying you don't actually have to buy a magazine or have a magazine to fire, and then you also don't necessarily need to purchase a magazine with a rifle. You can see how they had twisted the logic to come to the conclusion that the PLCAA is not applying to this type of firearm magazine and this type of part. In their petition, KCI goes on to point out that in this particular case, the lower court correctly cited to the prior District of Nevada opinion, holding that a bump stock was a component part of a firearm under the PLCAA. In that case, Prescott, the court defined component as meaning an essential constituent part, and as such, a bump stock was a component part of a firearm since rifle stocks, which included bump stocks, are necessary for a rifle to fire. Relying on Prescott, the lower court held in this case that since the rifle at issue can technically fire a single round without a magazine inserted, a magazine must not be essential to the rifle's use, and thus not a component part under the PLCAA. Under the court's logic, a bump stock is actually a component part protected by the PLCAA, but a magazine in an AR-15 is not a component part and therefore is not protected because they argue a magazine is not necessary to fire a single round. Under that logic, you could argue that bump stocks and really any stocks are not a component part because you don't have to have a stock on an AR-15 to fire it. However, the precedent in this area said that yes, a bump stock is a component part, a stock is a component part, but now all of a sudden a magazine is not. Also, a lot of parts are not necessary for you to be able to fire and therefore potentially wouldn't be protected. Think of things like optics, iron sights, a lot of other things, pistol grips, really, forward vertical grips, slings, a lot of things potentially, could be not component parts under this logic because they're not necessary to be firing the firearm. And therefore, maybe a third-party criminal that has a firearm with one of these accessories on it could then, engage in criminal conduct, and then a victim of that could sue these companies that maybe make a sling or maybe that make an optic. And here this precedent is setting up so that the PLCA would not protect those type of companies from those lawsuits. And based on that, they argue that it's time for the Supreme Court to step in. They argue that the Supreme Court should take review of this case, even though it's at an interlocutory posture, which is simply a middle ground, stage of this lawsuit. There has not been a determination on the final merits of the case, but they're arguing that the Supreme Court should step in right here and now because the PLCAA and the motion to dismiss should be granted and should have been granted because this case should not even be allowed to move forward. It should just end here because of what the PLCAA says. Now, this case was distributed for the Supreme Court conference. I believe it was like last week or 2 weeks ago. And the question was whether or not the Supreme Court would take up this case. Well, we just received an order from the Supreme Court that they have denied cert, i.e. they have denied review of this KCI case. Now, I said all along that this case was a long shot since the Supreme Court does not typically like to take cases up on an interlocutory posture, especially with cases in kind of novel issues like this one. This just means that the case will now proceed forward at the lower courts on the merits. However, this is somewhat concerning for future PLCAA lawsuits. We've already seen many anti-gun organizations be very aggressive with their negligence lawsuits and trying to pierce the veil of the PLCAA. We've seen some heavy settlements in relation to manufacturers being sued because of issues like this, certain shootings and things like that. So it's concerning that you now have a case moving forward, even despite the PLCAA. It happens quite often. And now you've even had the Supreme Court deny stepping in on this type of issue. So I just suspect that it will embolden these types of lawsuits moving forward, and we'll probably see even more pop up. So that's some news coming out of the Supreme Court. The Supreme Court has denied review of a firearms case. They have denied review of the PLCA's protection of potentially standard capacity magazines. And now we will see how this case moves forward. But if you have any questions, go ahead and comment down below and I will try to answer best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Also want to mention that a lot of you guys are mentioning that when you did go and check to see if you were unsubscribed from the channel, you found out that YouTube had unsubscribed you. So just go ahead, double check, make sure you're still subscribed to the channel. Sometimes weird things happen. And then also make sure you have all notifications clicked on. Click the bell icon and turn on all notifications because that also helps you to get all this information. And then just one kind of PSA, public services announcement. We are doing an event down in San Bernardino at Route 66 Shooting Sports Park this upcoming weekend on October 7th through 8th. So I'd love to see a lot of you guys out there. I will also leave links down below to where you can get more information. But again, this weekend, Route 66, San Bernardino, October 7th through 8th. I'll be there. Reno May will be there, Mike Glover, and a lot of other people. It's a great time. So please consider coming. It would be awesome to see a lot of you. But regardless, thank you guys so much for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.